March 8th, Wednesday morning, we have a Pac-12 update here at Peek Around the Corner. And we're also going to be talking about the Ivy League, a lawsuit aimed at the Ivy League. They're finally feeling the winds of change. Welcome to episode 161 of College Football's Peek Around the Corner with your host, Greg Pflugar. We cover everything in college football because we love everything in college football. And if you do as well, if you need a little bit of content to get you through the day, subscribe to our channel, smash that like button, share the video with your family and friends. We are not college football's Peek Around the Corner. We are truly not that if we are not covering this Ivy League lawsuit aimed directly at the conference. Let's get to the story right now, and then we're going to get to our Pac-12 update. As Yogi Berra said, it's getting late early. And then we added Pac-12 country. In Pac-12 country. Here we go. Let's get to the lawsuit. Ivy League. We're not going to go through the whole story, the whole article here in the Philadelphia Inquirer. We'll provide a link in the description box. You can read the whole thing. Federal lawsuits takes aim at the Ivy League's policy of no athletic scholarships. This could be massive, massive. Let's get to it. By Mike Jensen, published yesterday. A class action antitrust lawsuit filed Tuesday in United States District Court in Connecticut seeks to upend the Ivy League system of awarding financial aid to athletes only on the basis of financial need. That's the money shot in the article. Only on the basis of financial need. So this lawsuit is taking aim at that system. The two plaintiffs are current Brown University's one basketball player, Grace Kirk, and former Browns men's basketball player, Tamanding Chow. I apologize if I got the name incorrect. The suit says they are bringing the lawsuit on behalf of a class of fellow current and former Ivy League collegiate athletes. The suit alleges that under what is termed the Ivy League Agreement, not awarding athletic scholarships constitutes unlawful price fixing in violation of the Sherman Antitrust Act. We hope that this lawsuit will bring Ivy League athletes into the 21st century by subjecting these universities' treatment of Ivy League athletes to the antitrust laws, just as the courts have applied such laws to all other NCAA Division I athletic programs, says Eric Kramer, chairman of the firm Berger Monte, one of the attorneys for the athletes in a press conference. I think Eric Kramer, I think they have a great case to make. Absolutely a great case to make. Back to the article. The suit alleges that defendants are price fixing, and this agreement is per se illegal. It is naked restraint of trade among horizontal competitors. The allegation goes on to say, absent the Ivy League agreement, these schools would determine unilaterally in a competition with each other how many athletic scholarships to provide by sport in what amounts. So if it wasn't for that agreement, these schools would be competing against each other, and the student athletes would benefit from that competition with each other. Back to the article. It notes that Chow from Lowell, Massachusetts, played for the Browns men's basketball team from 2017 to 2022, and that Kirk from Duluth, Minnesota, has played for the women's basketball team. Each received at least one other full cost of attendance athletic scholarship offer from another school, according to the suit, noting that Brown did not cover full costs of attendance for either plaintiff. The issue has been percolating for several years. A pair of 1972 Penn graduates, Alan Cutler and Robert Litton, both attorneys, sent a letter in 2021 to the presidents of the 8 Ivy League schools and assorted others within the Ivy leadership structure with an 8-page memo calling into question whether the Ivy League would be able to continue to ban athletic scholarships. That memo It gave them a warning. Coulter and Litton, both attorneys now, both 1972 Penn graduates, 8-page memo calling into question. The letter began, "We respectfully write to you concerning the recent United States Supreme Court decision in NCAA versus Alston and how it affects the Ivy League's long-standing policy of providing financial aid based on need only." The reference was a 2021 Supreme Court decision when the High Court upheld the district court ruling that the NCAA can't enforce certain rules limiting the education-related benefits such as scholarships, such as postgraduate scholarships or other resources that colleges offer athletes as long as those are educational benefits. We're going to skip through some of this article. Again, I will put a link in the description box below the video. You can read the whole thing. If the Ivies had to compete for students, as other schools do now, through a merit scholarships for many different kinds, and by offering athletic scholarships for sports in which individual schools want to excel, the Ivy League schools' endowments are more than ample to allow them to do so, while continuing to provide full need-based aid to all, Coulter and Litton wrote in the 2021 memo. So what they're saying is, you can do it all, Ivy League. You can provide full need-based to all, those who need it, plus provide athletic scholarships in all different arrays of different kind of benefits to compete against each other in the Ivy League. Tuesday filing includes Justice Brett Kavanaugh's now often quoted concurring opinion in the Alston case. Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. I absolutely 100% agree. The Ivy League agreement, we at Peek Around the Corner believe it's going to truly fall and collapse, and it's going to benefit the student athletes. We're going to skip a few more parts of the article. The suit referred to a national trend towards recognizing the rights of college athletes to realize their market values in terms of educational benefits and compensation for their athletic services, going into some detail on recent name, image, and likeness developments, noting that the Ivy League has officially endorsed the NCAA's NIL policy. The Ivy League's history is noted, with the original Ivy League agreement in 1954 prohibiting athletic scholarships, that the Ivy League is now the only Division I league that now enforces such an agreement. The suit asked for a permanent injunction enjoining defendants from abiding by the Ivy League agreement or any equivalent horizontal agreement, and asked that the plaintiffs and other class members be awarded such other relief as the court may deem just and proper. The Ivy League agreement, back all the way in 1950s, it's going to collapse. It's going to be no good. It doesn't work anymore. We've seen Brett Kavanaugh's. We've seen the concurrent opinion in the NCAA versus Alston case. It all relates back to this. The student athletes cannot be barred, cannot be kept back from getting the compensation that they could potentially get if these schools truly were able to open up to competing against each other to get the best student athletes possible in an array of different options that they have in front of them. But the Ivy League agreement is collusion among the schools. It's collusion among the schools. Yeah, this is going to collapse. In our strongly held opinion here at Peek Around the Corner, the Ivy League agreement will be no more. We think this is a great federal lawsuit. It's going to win against the Ivy League. We're going to be keeping up on this story. We're going to be tracking this as close as possible. This is a peek around the corner to the new college football world that we're entering, the new college football sports. So stick with us. Put down your comments in the comment section below the video on what you believe what you think about this federal lawsuit. Now for our update, Pac-12 update this morning. If you've been listening to us on our live show this last Monday evening, last Saturday night, and all the weeks prior, look, there has been no comprehensive deal set forward to the Pac-12 presidents, even as of this morning. We were told by Arizona State Money Perch Saturday night, Monday night, we went through his letter number 5. It said that Arizona schools needed to see a comprehensive deal placed in front of them, at least one deal in the next 24 to 48 hours. That was Tuesday, and today, Wednesday. Yesterday, what did they receive? Nada. Nothing. They did not get the comprehensive deal placed in front of them. What does that mean? Does it mean there's really no good offer, no package deal that Kliavkoff can put in front of them, or are they still working on it? Can they get in front of those presidents today and put out a comprehensive deal? It has to happen. It has to happen, or these schools, these presidents, certain presidents, they're done waiting. They want to work on a deal with each other to see if it can work so they can get a deal done by April. There was a 48-hour period that this needed to get done. A comprehensive deal needed to be put in front of those presidents. It didn't happen yesterday. It did not happen yesterday. It has to happen today. And if they get something in front of them today, then they can work on it. There is still time. There's still time for the Pac-12 to get it together, to get a deal done. Now, one of the trepidations that the Arizona State, our Money Perch person who's been nailing this story from the very beginning, told us last evening, that there does seem to be an expectation that there will be a couple different offers, one presented. One of them, a comprehensive offer, one of them being a 5-6 year deal that is backloaded. Backloaded in the financial, backloaded in the payments, to where a 5-6 year deal, primarily a 6-7 year deal actually, and it would look good when it comes to the average money per year. It would be fully backloaded. The money would be pretty good in the back end of that 6-7 year deal. However, that would also include a traditional grant of rights, something that Oregon and Washington would have to sign. And that's probably a no-go. This is what their expectation is. This is what one of the offers they think they're going to get put in front of them. Again, it hasn't been done yet. The other offer is going to be that 3-4 year deal where Oregon and Washington could potentially sign off on it. But the money per year on that type of deal is going to be real low. Real low. And the exposure part of it's going to be similar. It's going to be the same between the 6-7 year deal and the 3 to 4, 5 year deal. So that's what their expectation is. They think they're going to get one comprehensive deal going from 6 to 7 years that's going to look good in the money because it's backloaded. And then the other deal is going to be 3 to 4 years that Oregon and Washington could possibly sign off on. But again, it's Wednesday. It's March 8th. It's in the morning. And no comprehensive deal has been put forward to the Pac-12 presidents at this time. And it has to happen now. Time is up. Time is up. According to what we are hearing from our source at Arizona State, it is time. Put forward the best comprehensive deals that you have in front of the presidents, and let's get to work. Let's hash it out. As Yogi Berra, we're going to say it again, as Yogi Berra said, it's getting late early. Today's the day. They need to see something. If it doesn't happen, if they don't even get to see a comprehensive deal in front of them today, well, things are going to happen, and it's going to happen fast. So stick with us here at Peek Around the Corner. Subscribe to our channel. We could pop up at any moment with a live show with breaking news. Until next time, and next time can be very soon from now. Until next time. From all of us at Peek Around the Corner, to all of you. Please, you all take care of each other. Thank you so very much.